everyone, and welcome to our Level Up Anniversary episode for South Carolina Legal Services. SCLS is a statewide law firm that provides civil legal services to protect the rights and represent the interests of low-income South Carolinians. To accomplish our mission, we offer legal resources and information in the form of webinars to the low-income community and those who assist them. The goals of these webinars are to help improve basic legal knowledge, avoid getting into difficult legal situations, and to improve the chances of resolving the legal problems yourself. The Level Up Law series that is presented every Tuesday at noon is a great vehicle for South Carolina Legal Services to achieve our goals. Funding from the South Carolina Bar Foundation and the creation and launch of Level Up Law series has been very helpful. We also want to thank all of the SCLS staff who stop what they are doing and answer the call to present. We are especially grateful to Susie Ingles, our consumer unit head, who leads the charge in selecting appropriate topics, lining up speakers, and ensuring that the productions run smoothly. Today's episode is special because it marks the 1-year anniversary of the Level Up Law series going live. We have an exciting treatment in store for you, so stay tuned and enjoy.
Hey everybody, I'm Rusty Infinger, and I'm going to be your host today for this anniversary edition of the South Carolina Legal Services Level Up Law series. I'm going to be talking to a few of our presenters. They are the top 6 series that we had throughout the year. So hang on, enjoy, and I hope you enjoy this anniversary edition.
On today's anniversary episode of Level Up Law, we'll be counting down the top 6 episodes from Level Up Law's first year of production. We'll start with Child Custody in South Carolina, presented by Melinda Taylor. Then we'll hear from Jenny Kaufman about Social Security overpayments and what you need to know. Next, we'll hear from Stephanie Vandehor about how to navigate unemployment benefits during COVID-19. Mark Fessler will then explain basic landlord-tenant rights in South Carolina in his episode, Rent Smart. Next, Taylor Ott will present her episode, Keep It Simple, Elder Law 101, our episode on advanced directives. Finally, we'll wrap up with the most watched episode of Level Up Law this year, Looking for a New Job, 10 Jobs and Business Opportunities That Might Be a Scam, presented by Susie Ingles.
In order to file a custody case in South Carolina, you've got to, there are some residency requirements. First of all, if both parties or all the parties live in South Carolina, then you certainly could file in South Carolina. However, if you've just moved to South Carolina from a different state, the child should have lived here at least 6 months. Now, there are exceptions to that, like if the child's in danger or maybe he's been abandoned in the state and things like that. Custody cases are usually filed in what we call the child's home state, which is defined as the state that the child last lived in for the last 6 months. Just to start with, if you have unwed parents, so a mother and a father that have a child together and they haven't been married to each other, then in South Carolina, the mother is actually going to have legal custody of the child. And that is until one of the parties goes to court to change that. So certainly a father could petition the court for legal custody or visitation of the child. But until that happens, then the mother would have legal custody and the right to allow or deny visitation with the father if they're unwed, if they've never been married. The father can either acknowledge paternity. A lot of times that's done at the birth of the child. where he is put on the birth certificate. Sometimes it's done in court where he and the mother acknowledge that he's the father, but it can also be done through DNA testing.
Hey everyone, we're here today with Melinda Taylor. Mindy is the family law unit head at South Carolina Legal Services, and Mindy's in our Columbia office. Mindy did a Level Up Law webinar series back in November where she talked about child custody cases. So we want to talk to her a little bit today about that webinar that she did and ask her a few follow-up questions. First of all, Mindy, let me just say congratulations. Yours was one of the 6 most viewed of all the Level Up Law series that have happened over the last year. You were talking about child custody in that series or in that webinar. Why do you think that the topic of child custody was so well viewed by that Level Up Law series, and in fact is one of the most viewed items in the South Carolina Legal Services website?
Well, I think that is probably pretty popular because so many people have custody and visitation issues, whether it's divorce or, just breaking up with the parent of, the parent of your child, or, and the children, it's 18 years that child custody and visitation can come up. So I think so many people have children, and it's always a very popular type of case that we encounter here at South Carolina Legal Services as well.
And my understanding is it's a pretty emotional part of the practice that you do in family law as well.
Right. It definitely can be very emotionally trying for parents or guardians, and it's definitely not something you want to enter into lightly.
Sure. I know that when we were doing this series, in particular your episode, we were sort of in the middle of the pandemic with COVID, and some of the things you talked about involved COVID issues. Now that we're transitioning out of COVID and that pandemic, what are you seeing as far as the courts in the family law arena getting back to normal?
So at this time, they're starting to have in-person hearings in most counties. They're still doing some virtual hearings, but in-person hearings are definitely back coming. They're starting to have trials again and contempts again. So I think that we're definitely headed in that direction of getting back to what we considered as normal operations of the courts. So hopefully with that, there'll be much more access to the courts.
Excellent. And one last question I want to ask you, Mindy, and that is, thinking back on this series that you did back in November, what would you say is the chief takeaway that our viewers today should maybe think about when they look at child custody and the information you gave to them?
Well, I think pursuing a custody case in family court shouldn't be entered into half-heartedly or lightly. It's an expensive process, and it's a very emotionally trying process that we had just discussed. It's hard. It's difficult. It's not something that's any fun at all. So I just think people should try to work with their child's other parent to come up with an agreement, and hopefully make some type of agreement and be able to co-parent better than just always jumping in and going straight for a litigation case. There's just too much risks and too much pain that happens, unfortunately. So I would just encourage people to reach out to their child's other parent, try to make some type of agreement, try to get along, try to co-parent with each other, support each other as parents, instead of fighting and litigating as much as possible. And just the other thing is the courts are always going to rule in what's the child's best interest and not necessarily what's in the parent's best interest. So And a lot of times that's something that's different. So parents need to remember that whenever they do go through this process.
Great. Well, thank you so much for your time today and for the excellent series that you provided. And we look forward to more of your information as we continue the Level Up Law webinars. Thanks.
All right. Thank you, Rusty.
These are basic rules about what you should do whenever you are dealing with Social Security. Remember, they are a very large agency and mistakes get made because they are understaffed. So you need to keep proof of what you file, make copies of everything you send them, and please make sure there is a date on any document you send them. We often forget to put that date on there, and it's critical so that it can remind you of when you sent it in to Social Security. There are online appeals and the ability to file documents. So if you do deal with Social Security online, make sure you print the receipt that it gives you at the end. If you don't have a printer at home, take a picture of your computer screen. Either the computer itself can take the picture, or you can take one with your phone. Anything you can do to capture what it was that you filed online. If you mail something to Social Security, please go into the post office and get proof of mailing. Or better yet, if you can afford it, send it certified mail, return receipt requested. That way you have proof that it was mailed and received. You need to remember, if you do not have proof you did something, it's going to be harder to argue with Social Security that you sent it. It's the biggest mistake that I see people making, is not having proof that they actually took something or mailed something to Social Security.
Hi, everyone. I'm here today with Jenny Kaufman. Jenny is in our Conway office here at South Carolina Legal Services, and she is the public benefits unit head for our law firm. Jenny had a series that you just saw a clip of where she talked about Social Security issues. Specifically, there was some discussion about overpayment, how that happens, and what you can do if that happens to you. So first of all, welcome, Jenny, and congratulations on being one of the 6 top videos that were viewed by our folks here that saw the Level Up Law series. When I look at your series, there's a couple of questions that we might ask. And the first one is, what do you think it is so hard for, or such a challenge for folks in South Carolina to navigate through the Social Security system here?
I think it's actually a national problem. The Social Security rules, even before COVID, are very complex, and there are so many different programs, and the rules are slightly different for each program. And you know, nobody can really keep track of all the rules, not even the people who work at Social Security. They are specialized just like law firms. So you just have to be patient with them and hope that they are patient with you.
I know that one of the things you talked about during the webinar was reminding people to wear a mask and some other tips whenever they actually went into the Social Security offices. We're now transitioning out of COVID. What's the current status of the Social Security offices as you're seeing them across the state?
They are still closed, and they are supposed to submit a return to the office plan to the president by the middle of July. The concerns with Social Security are that their population, the people that they serve, are very vulnerable. They are older and they are mostly disabled. And then so until there's more people vaccinated And people are wearing masks when they go into these small offices. Social Security is probably going to remain closed. You have to remember, it is the face of the federal government for many, many people. And their offices are small, but their clientele or consumers are numerous.
We're sure that I think that's helpful, trying to letting people be updated on that. Another thing that you talked about as we move forward with people continuing to work through these issues with their Social Security cases, you mentioned that the most important rule was keeping your records and making copies of what you send to them. Is that still important, even though we were talking about that in the world of COVID?
Oh, it's always been important. I had a client recently who was notified that he still owed money on an overpayment from 2001, which he thought had been waived. And he actually had kept his notice that said it had been waived. And so he was able to submit it, and Social Security accepted it, and he doesn't have to pay the money back.
Good. Still very good advice.
Yeah.
Well, finally, I want to just ask you, when you look back at that series and your particular edition, what would you say is the one takeaway you would want folks today to take away from that series that you had on Social Security benefits?
I think the biggest takeaway for me is that you need to respond to any notice from Social Security. You can't just wait and hope that it goes away. If you don't respond, they're going to take your benefits, and for some people that means their entire check. So it's better to be proactive than try to fix it after your benefits have stopped.
Good. Well, thanks again, Jenny, for your time today, and congratulations on one of the most viewed. The other thing that's interesting about yours is that you had the most comments and questions during the actual session. So it's very important to our clients and to our viewers here on this information. So thanks for your help, and look forward to chatting with you soon.
Y'all take care.
Okay,
wear a
bye-bye.
mask and get vaccinated. Bye.
When should you apply for unemployment insurance benefits? So you should apply as soon as your employment circumstances change. So that means as soon as you are terminated, as soon as your hours are reduced, as soon as you're laid off. You should still apply even if your employer tells you not to apply, if your employer is still open, or if your work hours were reduced, because you can, in some circumstances, qualify for unemployment insurance even if you are still working part-time. So you can earn up to 25% of your weekly benefit amount. So if you're earning without receiving a reduction in payment. So if your weekly benefit amount is $326, you can earn up to 25% of that, which is about $70, without the department reducing your weekly claim. I know it's not very much. If you're making $10 an hour, you can basically work approximately 10 hours a week, or 7 hours a week. Okay, so the earlier you apply, the earlier you can begin to receive benefits. So while it may take some time for your claim to be processed and approved, you will be paid retroactively back to the date that you applied for benefits. I know that some individuals have had trouble logging on to even apply for benefits, and the department has established a committee to review those complaints to see if benefits can be applied retroactively to prior to the date that you apply. So if you were laid off, let's say March 22nd, but you tried to apply for benefits for 2 weeks and you weren't able to apply until, let's say, April 4th, you can notify the department that you had that issue, and they will review your claim to see if you can get benefits back to the date of your separation.
Hey everybody, I'm here today with Stephanie Vandehor. Stephanie is in our Charleston office, and she is the Employment Law Unit Head here at South Carolina Legal Services. You just saw a clip of Stephanie's Level Up Law webinar where she talked about unemployment, especially with regard to what people were dealing with during the COVID-19 pandemic and how you could apply for benefits, appeal those, any denials, and other things related to that. So Stephanie, first of all, congratulations. You are one of the 6 top most viewed Level Up Law webinar series. So glad.
Thank you.
So now that people have seen that or maybe have reviewed your series, if somebody is still dealing with unemployment benefits, even though we're getting outside of the pandemic, what kind of tips or information would you give to them now as far as moving forward with that?
So we are still very much in the unemployment benefits appeals process from what I am seeing. And so the most important thing I think still is that if you receive a determination, whether it be for eligibility for benefits or for an overpayment, that you appeal, so that you, have the ability to challenge that determination should you need to, and to give you time to contact the Department of Employment and Workforce, see exactly what's happening, and or contact an attorney if you need one. And I just want to add that generally unemployment benefits only last 20 weeks. That's the maximum amount of benefits that you can get here in South Carolina. And any redeterminations that are being issued or overpayment notices that are being issued now, where pre-pandemic they would have been for a maximum of like $6,200, we are, consistently seeing overpayment amounts of over $20,000. So that can be certainly a big, big, big problem and obstacle for our clients who, they don't make $20,000 a year. So how are they going to repay $20,000 in benefits? And so just to see what your options are and to kind of get a handle on everything, and to see maybe if it's, maybe you are eligible and you should still be receiving benefits, or you shouldn't have been determined to be ineligible. So that's the most important thing, is to appeal.
Excellent.
Okay.
And we know that we are transitioning out of the whole COVID-19 pandemic issue. We also, many of us have heard news articles and other information about what's happening now. So if you could just sort of update our viewers on where we are in the world of unemployment benefits now.
Right. So and in the middle of April 18th, the work search requirement for eligibility for unemployment benefits was reinstituted. It was waived during the pandemic. So beginning the week of April 18th, individuals had to complete those work search incidents through the Department of Employment and Workforce's site. It's CWOS. It's connected to the portal. What I'm seeing is there seems to be, if you are doing the work searches, they're not being certified, they're not like being registered in your portal, and it's coming up that you haven't done them. So we're seeing denials for benefits for that reason. That's an appealable issue. And I think that has a lot to do with the fact that they had been waived for so long and now they're being transitioned back in, and there's probably some software glitches going on with that. The other thing is that South Carolina is one of several states that has decided to discontinue federal benefit programs at the end of June. So those extended benefits that individuals had an opportunity to receive, the PEUC, Pandemic Emergency Unemployment Compensation, PUA, pandemic unemployment assistance, and FPUC, federal pandemic unemployment compensation, all of those programs will end the last week in June. So, individuals need to look to transition back into the workforce. Securing childcare, if that's the reason that you've been unable to return to the workforce, find a new employment if your previous employment is no longer available. For those who had been advised by a medical professional to quarantine because of underlying medical conditions, they should be aware that after that date, there will be no continued assistance under unemployment benefits available.
Well, thank you, Stephanie. Those are still very important topics to all of our clients and folks viewing this. So appreciate your time and look forward to chatting with you again. Thank you.
Thanks. Always a pleasure, Rusty.
Bye.
Where do the rights that a landlord or a tenant have come from? Predominantly, they're going to come from the rental agreement, the contract. So quite frequently when a client says, can I do this or can I do that, or can the landlord do this or the landlord do that, or charge me this or that, my first response is going to be, well, what does the lease say? What does the contract say? A contract is simply a private agreement between two parties that sets forth rights and responsibilities that those parties have. It's often the case that things are left out of a contract. So a contract is not necessarily going to be all-inclusive or comprehensive, but it should hopefully be as comprehensive as possible. In a rental agreement can be either verbal or written. It doesn't have to be written. Any rental agreement that intends to last for longer than a year has to be in writing to be enforceable. So if you have a verbal agreement that you can stay here as long as you want, but that agreement's not in writing, then the law's going to treat that as a month-to-month rental agreement. But it's still a rental agreement, even though it's verbal. The rental agreement should set out what the rent is, what property is being leased, what the due date for the rent is. Those are probably the three fundamental requirements that you need to have a basic rental agreement. Now, in addition to the rental agreement, there's also the Residential Landlord-Tenant Act. There are also some what are called common law rules, which are basically just rules that courts have developed over time to make decisions in various cases. And that's generally called the law. And the law can fill in certain gaps. So let's say that there's a conflict in your lease agreement about what your rent due date is. Let's say that at one point in the rent agreement, it says your rent is due on the 1st, but then at another point in the rent agreement, it says the rent is due by the end of the previous month. Well, the natural interpretation of that would be that it's due by the last day of the previous month. So there's a discrepancy there. So a common law rule that the courts have developed is that if there's a conflict in terms, or what's called an ambiguity, the courts are going to construe that ambiguity against the drafter of the document. So most often the drafter is going to be the landlord, so the court should find that the due date in this hypothetical scenario is the 1st of the month.
Big thing here is you don't need both. The healthcare power of attorney is broader, gives more power to who you choose as an agent. And if you do choose to have both, you want to make sure that they're consistent with each other. Because if they're inconsistent, then the living will actually trump the healthcare power of attorney. So you may name a healthcare agent in your healthcare power of attorney who is allowed to have total decision-making on your behalf when it comes to life-sustaining treatment, artificial nutrition, and hydration. But your living will says you don't want either of those if you're in a permanently vegetative state or terminal.
that in that situation, the agent would actually have to follow what's in the living will. So you want to make sure if you are thinking about doing either one of these documents, you need to figure out first, have you ever done either one of them before? And if you have, you need to consider possibly revoking or undoing one of the former documents that you've gone ahead and done so that your wishes are either consistent or you're now moving on with a different set of decision making.
Hey, I'm here today with Taylor Ott. Taylor is in our Orangeburg office here at South Carolina Legal Service, and Taylor is the Elder Law Unit Head. Taylor did a presentation with the Level Up Law series where she talked about a number of topics, primarily on advanced directives. She had some questions about wills, powers of attorney, and a lot of probate type matters. So today we're going to chat briefly with Taylor to talk about that series as we celebrate the 1-year anniversary of Level Up Law. And Taylor, congratulations. Yours was one of the top 6 webinars that were viewed by our audience. So we celebrate that. In any event, so let me first of all by saying, just give everybody a quick reminder on exactly what is an advanced directive.
So an advanced directive is going to be any document or plan that you try to put into play in regard to your wishes for your estate and the things that you own after your death, or planning in advance and making your wishes known about end of life medical treatment, or putting into place the ability for somebody else to make financial and basically business operating decisions for you prior to death. So those in general are referred to as advanced directives. Specifically, they would be last will and testament, healthcare power of attorney, living will, a durable power of attorney, and then there's also something that you can have a physician put into your electronic medical record, and that is called a physician order for scope of treatment. That's relatively new. All of those we discuss at greater length in that presentation from August.
Good. And I know that a lot of folks were viewing some of these webinars during COVID and trying to get their affairs in order because of the pandemic. But now that we're transitioning out of COVID, would you say that this is still very important for our viewers to continue to make sure they have these type of documents done?
So as elder law unit head, and especially as an attorney that also does a lot of probate court, estate administration, litigation, guardianships, that sort of thing, it is better as an attorney to help somebody make those decisions ahead of time, for them to be able to exercise control over medical treatment, or indicating to the court who they would want involved if a court appointed person to make medical or financial decisions. It's always better to plan that ahead of time. So I think the difference that we saw with COVID was people finally really thinking about end of life medical decisions. I think the typical client pre-COVID for an advanced directive was either somebody who was a little bit more senior in age, or someone who had dealt with a health crisis of a loved one and been in a position where they didn't know what that person's opinion would have been about end of life medical care or their assets after death. And so I think it changed both the number of these people that we've been able to assist in the last year, and then also dramatically changed the demographics of the counties that we were serving these clients in, and then the number of people that were interested in, especially healthcare powers of attorney, when normally we might just be doing a last will and testament for them. So I think that COVID certainly had increased people's awareness of health needs, and especially, at the different peaks, I suppose there's been more than one, of cases and hospital bed usage. It was something where people who would normally not have to consider their desires about mechanical ventilation and supplemental nutrition normally wouldn't even have to think about that, or having friends and family in those circumstances. I think everybody has known somebody directly impacted by COVID and having to receive medical care from it. And I think that there is still a need for people to have advanced directives in place. And so my hope would be that we continue to identify and be able to serve people who have been outside of our targeted demographics in the past. So we continue to function as an office through COVID and be open and provide services. but we were able to actually do 2 on-site clinics in our region for advanced directives in some of our rural counties. And so those are people who are living in our rural counties, primarily serving people who are over the age of 60 and at the greatest risk for, complications and more serious COVID, that came out, I wouldn't say in droves to have those done, but the need was still there. That was early March. Need was still there to have done, and we are, wrapping up finally being able to fully serve those clients. So there's still a need, there's still the ability to get those done, and I think it remains an important thing.
Great. Another thing I wanted to ask you about, because this has been on everyone's mind, we know that courts were shut down for a while, and then they started having some limited activity. And most of the work that you're doing is in the probate courts. Where are we now in the COVID, post-COVID sort of atmosphere with respect to probate courts in South Carolina?
So in the 6 counties that we work in, I think all of them are operational with having staff in the office. I think I can think of 2 in particular where some staff are still remote, but they have somebody there. So the 2 ways they're operating is either with a Dropbox and doing all appointments by phone. So you would, if you needed to file something related to an estate, that you would drop it off and it'd be clocked the following day. And then there are some offices that will have set hours. So here in Orangeburg, the office is open and, she might hold court, but as far as filing something or being able to go in and examine files, that's limited even for attorneys for hours in the morning, which I totally understand. And so with the advanced directives that we've talked about briefly today and at greater length in that presentation, none of those are things that have to be filed in the probate court, except with the durable power of attorney that gets recorded with the Register of Deeds. Those offices have some of the same limitations that I talked about with the probate court. They may allow one person to come in at a time, but I can't think of any of those offices that are requiring appointments or only doing things by like a Dropbox. So there's a small recording fee for a durable power of attorney. So I think the same thing that you're going to see with probate court. So I advised in the presentation, and honestly myself will call ahead of time before I bother to drive over to a courthouse to make sure I understand what the limitations they may have changed. And they've been progressively going back to operating as normal.
And finally, Taylor, if you could tell us, what would you say would be the one takeaway or the biggest takeaway someone might want to get from your Level Up Law series on Elder Law 101?
So I think the most important thing, if you're not considering executing a document at this point, is to at least consider having conversations with loved ones about your end of life wishes. So if you tell somebody what you want to happen to your things after you die, that's not binding. So you want to make sure you understand if you have desires that you want to make sure are followed, you need to make sure you have that in the appropriate documentation. But at the very least, if there's ever going to be somebody else that needs to make medical decisions for you, even if you're not executing a healthcare power of attorney or a living will, you need to make sure that the family members that are already providing some assistance or support in those areas know what your wishes are, because the court, if they appointed a guardian for you to make medical decisions, is going to be duty bound to act in your best interest. But part of that is also following the wishes that you might have. So the clearest and most appropriate way to make your wishes known is in a document, but also to have those conversations with family members so they're aware of what your wishes are.
Sure. Well, thanks again for your time and for your excellent presentation, and we appreciate your service.
Thank you.
If you're looking for a job or a business opportunity or guaranteed income, we don't want you to run off the road when you're looking for those. So steer clear of some of these schemes that we're going to be talking about that promise money but don't always deliver. The first one is envelope stuffing schemes. Now, these are job offers that say, oh, it's very easy, you can do it from home, just stuff these envelopes and you'll make lots of money. But in fact, you end up not having anyone to stuff the envelopes for, or you've spent money on envelopes or some sort of equipment, and then there's nobody to stuff envelopes for. So just be careful about that as a way to earn money. Telemarketing resale scams. These are alleged opportunities where you're going to be allegedly selling brand name merchandise from home. And it seems like, wow, that's great. But, you know, sometimes that's something that you can do on your own through eBay and Facebook, some of those other resources, without doing it through someone else. Because if you're doing it through someone else, you really don't have any control over it, and you end up not making any money, and they make money from you.
Hey everybody, I'm here today talking with Susie Ingles. Susie is a staff attorney in the Greenville office in South Carolina Legal Services. She's also the consumer law unit head. So Susie did a webinar series with Level Up Law that you just saw about scams that are out there for people seeking job opportunities, etc. And so now that we've seen this little clip from Susie, I want to ask her a few questions about some of these scams that she talked about. So Susie, welcome. Thank you for being here.
My pleasure.
And congratulations to Susie, because of all the Level Up Law series we did, Susie's was the #1 rated in the series. So why do you think that series, Susie, was the #1 that people viewed?
Well, one thing is I have to admit that it was the first one that we did a year ago, and so that video has had a lot more opportunity to be viewed since then. However, since the topic was job scams and fraud, we were right in the middle of the pandemic. People were quarantined, losing their jobs, looking for work, any way that they could get income. And so I think anything about jobs was a good topic. And, you know, job scams are out there, and there is no exception when it comes to COVID. A lot of the job scams and frauds had to do with COVID, selling COVID products, helping make masks but having to pay to do it, things like that. So it was pretty relevant at the time.
Well, and just following up on that, you know, COVID did have a huge impact on job opportunities. How do you think that's going to change now that we're transitioning out of COVID?
Right. Well, I think one thing we have to think about is so many people lost their jobs, and they may not be getting that same type of job back. And so, you know, really nobody is immune from job scams and frauds and other kinds of schemes. And so as people are trying to get back in the workforce, trying to get, you know, potentially a new type of job different than what they had, anything is going to be attractive. And many of the scams out there are going to be involved with working from home, or, you know, doing a job at odd hours and things like that, and those are going to be attractive to people. And those are people potentially who haven't had to look for a job in a long time, and so they may be very well vulnerable to some of the fraudsters out there.
Well, for sure, this is a very relevant topic, not only during COVID, but now.
Mm-hmm.
But taking a look back at your Level Up Law webinar series, this particular topic, what would you say is the one takeaway that you would want our viewers to think about as they review that?
Well, I think the main takeaway that everybody needs to think about is when it comes to scams and fraudsters and all kinds of schemes that are out there, it can happen to anybody. And particularly people who have been out of work, it's probably the most vulnerable group But it can happen to anybody. It's, happen to people, I'm sure, who you know or are related to, and no one can escape it. So you got to be careful out there. That's the big takeaway, really, is beware of the scammers.
Absolutely, good information. Well, thanks again, Susie, for being here. Take a look at her entire series on this very important topic.
Thanks, Rusty.
Hi everyone, my name is Holly Webster. I'm a new attorney here at South Carolina Legal Services in Greenville, and I'm originally from Florida. So I have been watching the Level Up Law videos since I started working here, and what's interesting is they were made to help people in the community learn about their rights in the different areas of the law, but I've been watching them and they've been really helping me learn about the different areas, and it has been really cool to see coworkers making their videos, and I was able to catch up with them, visit their office, and ask them more questions about the videos they've made. And so for me, it's been an incredibly beneficial, super helpful videos for me to watch, and I still have some more to watch, and I look forward to learning more about our laws.
We hope you've enjoyed this anniversary episode for Level Up Law and that you continue to join us for future webinars. We are always here to help, and you can apply for services on our website, www.sclegal.org.